Good evening to everyone, wherever you are. My name is Dean Gerber. You may know I was immediate past president of ISTAT, and I am delighted to be moderating today's session on truly one of my favorite topics. And if you don't believe me, ask my children or anyone I know, because I do speak a lot about the Cape Town Convention. And we've been through a pandemic. We've been through quite a bit over the last few years. The treaty has been tested, and there's been a lot of discussion about it, and perhaps some unwarranted criticism of the treaty. But I thought that in thinking about this learning lab, it made sense to kind of assess and take stock of the treaty and consider where it's been, where we are, and perhaps where we're going with it. And in thinking about who might be suitable to speak on such a topic, I could think of no one better than Jeffrey Wohl, our featured speaker today. Jeffrey is Secretary General of the Aviation Working Group. He's Senior Research Fellow at Harris Manchester College in Oxford. He's a Senior Advisor for Watson Farley. And in my humble estimation, he may be top two knowledgeable people on the planet about the treaty, the other being Sir Roy Good, who wrote the definitive text on commentary on the treaty. Jeffrey's been involved in it from the outset. I've known Jeffrey since the early 90s when he was a practicing lawyer at Perkins Coie in Seattle. We worked on transactions together, and he is truly a transformational figure in our industry. And what he's been able to do with the AWG is nothing short of remarkable. So let me introduce Jeffrey, say thank you for joining us and giving us some of your time today to speak on a topic that's, I know it's near and dear to both of our hearts. I've worked with Jeffrey on the legal advisory panel of the Aviation Working Group for many, many years. I've been involved, active, currently I'm the ORIX representative on the AWG. And I get to see firsthand the time, effort, sweat equity that he puts into this. So Jeffrey, welcome, and thank you for joining us today.
Dean, thank you. I still haven't recovered from the shellacking I took from negotiating with you when we were both even younger than we are today. But looking at this picture of you, you clearly have found the fountain of youth, and I hope you transmit a bit of that to me in this session. It's a pleasure to be here. You don't have to ask my children about my fidelity to the Cape Town Convention. I've carved the convention under one eye and the protocol under the other eye, so I could dream and contemplate it every night. So hopefully with that background, I'm prepared to make some contribution today, Dean.
Well, thank you for that. And let's get started, because the first order of business is perhaps taking a look back. You know, you were there from the beginning, and maybe you could discuss the origins of the treaty and the assessed need at the time. You know, who were the critical players, and maybe some of the process challenges that you faced in coming up with the final text.
You know, I think one way to look at this set of questions is to compare kind of where we are now against the objectives at the beginning. I think today, and we'll get through this during our session, I think it's safe to say that the treaty has substantially improved the law all over the world, has had a fundamental positive effect on financing and its terms, has opened the windows for different types of financing structures in places where they weren't possible. And as you alluded to earlier, has really provided a rock of stability during, you know, the COVID crisis that we had, relying on the rule of law to do transactions in the most difficult setting. So how does that compare to what we tried to do back in 1994 and what the original objectives were? I think it's fair to say also that when we started the process in the late 90s, what did the world look like? What did the aviation finance world look like in 1994, 1995 when we started? This was a period of time when India, Russia, China, Brazil, other countries were coming into the air finance system with background laws and institutions that really were not suitable for the needs of international finance. And they're all not the same. I mean, China and Russia were, communist systems, basic fundamental principles were very different. And none of that mattered all too much when the governments were provided the ownership and the control and the support for the airlines and were willing to guarantee debt. But as we saw in the 90s, that situation was changing. These large countries are coming in, buying large amount of aircraft. Things were becoming more and more private. The direction of travel was one way away from state ownership. Parties were taking, a lot more risk, and it was, essential that we had a framework that facilitated transactions with that level of commercial risk, non-sovereign risk. And so against that backdrop, Boeing and Airbus, as the benevolent oligarchs at the time, looked forward and saw, the way the wind was blowing, and put together a group, the Aviation Working Group, with other key players to put our heads together and say, what would we want, as an industry, the legal framework to be for leasing and secure transactions and bankruptcy in a world in which countries of this type were coming into the markets without government support. And that was really the starting point. And I should say that it was positive and unique and maybe surprising how the major players in the industry closed ranks slowly but surely. We formed a legal group. Dean, you're an important part of it. Supporting the movement away from past practices to a new framework in many ways, and the same with industry. We had a number of issues that were difficult issues at the time. I can just give one. Seems like a small issue now, but the fact that it's a small issue shows you how far we came. Back in the 90s, there was a raging kind of dispute as to whether an engine was a part of an aircraft or whether it was its own property and should be treated as its own property and should be separately financed. And the treaty came down hard on engines are separate, they're separately financed, they should be registered. And I think that contributed to the rise of engine leasing and even the creation of companies that did it. But it was, the coming together of all the parties. What were the challenges and the processes? I think the most important thing, if we look back, the biggest challenge and element that we had to get sort of our minds around is that we were negotiating a treaty. Now, treaties take a long time. The preliminary work started in the mid 90s. The diplomatic conference where the treaty was adopted was in 2001. The treaty came into force in 2006. It took time for countries to adopt. Treaties take a long time, and the industry, it's not natural for industry to look at a long-term process of this type when we're looking at the next transaction that needs to be done. But the benefits of the treaty, which we anticipated, and I think they've been true, they've been there, is that a treaty has the force of international law. Now, international law doesn't carry with it an enforcing army, but countries don't like to violate international law. They don't say that they do. Even Russia went through every possible line of reasoning to take issue with the fact that they violated international law in their behavior. People just don't like to do it. And so having international law on one side, is positive. The reputational cost to a country from violating a treaty, the peer pressure, and the measure of uniformity, we'll get into uniformity in a second, all those things were present. And that trade-off was an important trade-off. I'm glad we made it, but it took some staying power and some endurance to get through it. The more immediate problems that we had in the early days, I think really fell into kind of two categories, and I'll leave aside things we'll be dealing with in future slides coming up. But the largest battle that we had was while we partnered with the world's government in an unprecedented way, UNIDROIT, which is an intergovernmental organization, all the credit in the world to them that they took us in and negotiated fairly and openly in a sophisticated way, balancing the interests of industry with government industries and government interests and their own interests. But I would say that the largest challenge was sort of convincing the world that the treaty should be based on precise rules and that parties could rely upon in a predictable way when they entered into a transaction. That is, to have a rule-based system which prioritized ex ante predictability at the time of a transaction, rather than a vague standard that anyone could point to in court after the fact. That discussion, an age-old discussion, I might add, was really the biggest challenge. And we tackled it every imaginable way, and we ended up succeeding. We had to make one compromise instead of making 50 compromises, and that compromise was to permit countries to make declarations, to make choices when they ratify. We'll get to that later. I won't say more now. But by offering countries the ability to kind of modify the extent to which they were moving to this new rule-based system, it permitted us to have accepted that there should be the rule-based system. The other challenge, looking back, and you still see, residue of the challenge, is, for lack of a better phrase, I'll just call it, vested interest resistance. There clearly are people at times and places who don't want change, or that think that change hurts them or comparatively hurts them, and things are just fine the way they are. Can't downplay that. That was a challenge. History has shown, that careful, considered change is a good thing, and that was the case here. And the treaty is an efficient system, and history shows that efficiency, in the end, prevails over that sort of interest. But I'd say those were the main challenges if we look at the world in 1994, 1995.
Well, thank you for that backdrop. It's really important to understand. This treaty is not easy. It's not a simple treaty. It's a complex body of law. And I imagine that the ratification process, as a result, was challenging, because think about it, you've got countries that are adopting governing law in their jurisdiction that may well be completely contrary to their existing law. They may not know what the terms precisely mean at the time they look at the treaty, and then at some point they need to implement that into their national law. It's an enormous process. We take it for granted, say, in the United States, because much of the treaty is consistent with our existing laws, and the concepts are not new. So let's talk about, the ratification process and the key elements needed for proper implementation, and how you assess the growth of the treaty in the 22 years since it was finalized.
I think the starting point in this frame is, I used to say, and Dean, I know you've heard me say this a long time ago, that the Cape Town Convention effort was really, it really had a commercial objective, which was to facilitate finance, pursued via a diplomatic process with law as its subject matter. And I think understanding those three elements, sort of commercial, diplomatic, legal content, and the synthesis is the starting point in understanding this. Adopting a treaty is a diplomatic process. And so one has to adjust one's thinking, and we did, from the very beginning. And when you're in a diplomatic process with diplomats, they may have a few technical advisors, but as Dean said, this is a complex treaty, although, Dean knows I'm a simple guy, but this is a pretty complex treaty. And to negotiate something like this with, diplomats who don't have a commercial background, you need to speak their language. And their language was initially, we're a country, we're sovereign, we don't want to change our law, we don't want to adopt some international standard. That was the kind of the reflex, of most diplomats, and people had to really work through that point and to say, first and foremost, there is a history in aviation of an international character. That is, there's a lot of international law. There's always been a lot of international law. You have moved to international law in many areas in aviation, very sensitive areas like liability for plane crashes. You move past your own tort law to international systems. Aircraft move all over the place. Litigation could take place anywhere. Aircraft you could think you are protecting your culture and your values by being protectionist, but an aircraft could easily be repossessed at JFK or Heathrow, and it will be. You have an international problem, you need an international solution. And so we had to spend a lot of time sort of explaining this wasn't a question of sovereignty. We're not talking about something other than an international commercial action that needs to be viewed in that light. And I think once we sort of overcame that hurdle, that we look at this in the context, then we moved away from that sort of kind of simple-minded approach, that kind of a diplomat might take in negotiating a diplomatic treaty, and then one started to look much more in a more focused way at these declarations that were to be made. As I said earlier, the ratification process, unlike almost every other treaty, was not yes or no. It was that different choices need to be made, and the choices that needed to be made were on the most important issues. I'm going to we're going to come to the details of that in a second, but the ratification process did require very kind of precise thinking about about what should happen in bankruptcy, how quickly courts should act, what should be the degree of discretion that administrative officials had in connection with the deregistration of an aircraft. These were questions which needed to be tied into the commercial objective, back to my saying commercial objective via diplomatic means with laws as subject matter. There needed to be a constant sort of translation function between these legal features and the commercial objective. We tried to do that through commissioning economic impact assessments, which try to unbundle these points and show the linkages and the connections. But the questions of insolvency and timetables, which we'll come to in the next in a bit, played an absolutely central role in the microanalysis of that. We ran into some problems with some of our closest friends, like UNIDWA, an international organization, judges its success criteria would be how many countries ratified the treaty. Our success criteria was how did they ratify it. Ratification without these declarations that made a difference really meant nothing to us. So we weren't counting numbers, although the numbers now above almost 85, but we were looking at the quality. I remember Canada, and you'll remember this, Dean, Canada had trouble making the bankruptcy declaration because of constitutional issues. And they wanted to move ahead with the ratification of everything except bankruptcy. And we asked them not to. We said, please do not ratify the treaty, and upset a lot of people by saying that, because, the idea was to achieve the commercial objective of improving the law materially, increasing financing, the availability, increasing the terms, and providing more certainty. And by simply looking for a diplomatic victory, that's not how we viewed the world. So for us, it was all about what declarations were made. Moving past that, I remember when we started this, the word implementation means lots of things to lots of people. I think it was the AWG that really got the most systematic on what the word implementation meant and what the word compliance with the treaty means in this context. And we did some early work saying it is not enough that a country ratifies the treaty and makes the right declarations. What's important is that parties can rely in their transaction on the ratification and the declarations made. And as we analyzed that, it really meant kind of two things. It meant that what we call implementation, that the treaty needed to be, actions need to be taken in accordance with national law, which ensured that the treaty prevailed over conflicting law in the case of a conflict. This happens all the time. Now, when we first made a big deal of this, countries said to us, it is borderline insulting for the AWG to be raising this point. Of course, we're not going to ratify a treaty and then violate international law by not having the treaty apply. And how dare you? Ministries of Foreign Affairs wouldn't do this thing. That was completely wrong. We found that, that 5 times out of 10 left to their own devices, probably because of the complexity of the treaty and the intricacies of bankruptcy law, that unless a purposeful effort was made to ensure that the treaty prevails, we'll talk about India in a bit, where this issue is front and center right now. Countries would not do that. They would take the path of least resistance and pass the law, and let's see what happens when things conflict. So we spent a lot of time saying, no, implementation means that the treaty must prevail as a matter of national law in the case of a conflict with old law, which we're trying to move past. And in addition, it needed to be complete. In other words, it didn't matter if theoretically the treaty would prevail over conflicting law, but the judge or the Civil Aviation Authority didn't have sufficient knowledge, information, and materials to reach that conclusion. What's the point? We go back to our starting objective. The ability to rely upon the treaty in the commercial context means that when it comes up, it would be enforced. If a Civil Aviation Authority, it's cold comfort to say, under your law, if you went to the Supreme Court, the answer would be X, but the poor person at the Civil Aviation Authority in his or her manual doesn't have the rules to implement the treaty. Months and months of delay and costs result. So implementation meant primacy of the treaty and completeness and usability. We continue to work through those issues all the time on socialization, education. Our legal advisory panel works tirelessly on educating courts, which I'll come to later, administrative authorities, on the right thing to do. Our starting point was educating lawyers around the world. We have, a document called the Practitioner's Guide. It's now in our it's on the AWG website. My esteemed moderator was the coordinator of that process, but that document is the one that really helped educate the lawyers. I mean, this is not a critique of the lawyers. They didn't go to law school learning the Cape Town Convention. They learned their own law. They learn specific international aviation finance law. So we had to do a lot of education, and we continue to do that. Over the last 85 years, 22 years, we have 85 countries in the system. We have had an enormous, experience base. If we look only at COVID period, during the COVID period, we discussed and argued with about 40 countries about why they shouldn't amend their law in a protectionist way to, limit or change the bankruptcy rules or change the enforcement. COVID was the biggest, crisis we've ever faced in our industry and in any industry. And there was a natural reaction to pass protectionist law and view this as an emergency. The Cape Town Convention stood the test of time. It provided a rock solid framework to negotiate and renegotiate in the most challenging time. Of course, people did not want their aircraft back at that time. Cape Town wasn't tested in that sense, but it was tested as a bedrock for rule of law thinking, in a very difficult circumstance. So I think that, and we'll talk a bit about the future, later on, but I think that we can say that the number of countries from civil law and common law systems, from developing and developed jurisdictions that came into the system, the number of cases we've seen, the problems we've dealt with has been enormous. Are there continuing problems? Of course there are. Are we learning all the time from them? We are. I think that if one had to make one general kind of statement, I cannot think of a single case in which financiers or lessors were not in a materially better position because of Cape Town than they would have been without it. Sometimes they're in a perfect position. Sometimes, they're upset. Well, if Cape Town worked perfectly, I would have gotten my aircraft back in X days, and it was, X times 2. But X times 2 is probably 50% of what it would have been like back in the day. So one has to understand we're dealing with a big world. We're dealing with a complicated instrument. We're dealing with lots of different countries. And I think by that measure, the growth has been phenomenal. Will we rest on our laurels? Of course not. We work tirelessly every day. But the qualitative and the comparative benefit without Cape Town is enormous.
I agree with all that. And I think it's important for people to understand that the implementation issue is a very signature and critical issue. A lot of people go on the UNIDROIT website and say countries, ratified the treaty, and they think that's the end of the day. That's the beginning of the analysis. That's not the end. That just means that they deposited the proper papers in the proper place and got on the list. But you need to look beyond that, and you need lawyers within country to give you sound advice about proper implementation, how it's going to work. In terms of number of ratifications, treaty has been enormously successful in that in a mere 22 years. Potentially one of the more successful commercial law treaties you're ever going to find, given the speed with which the ratifications of that number of countries occurred. And then I think a lot of what you're talking about is our proper growing pains. The treaty, as we said, is complex. I always harken back to my experience with Section 1110 in the United States, which is the keynote bankruptcy provision protecting creditors in a U.S. airline bankruptcy. That treaty went through, or that statute went through a number of bumps and amendments over the years to address problems, because it wasn't, even though it seemed clear on its face, problems arose during airline bankruptcies, and it wasn't smooth sailing up until the point where we are now, where it's predictable, understandable, and everyone kind of knows how it's going to work. So again, in the time that the treaty's been live and effective, I think it really has done quite well and performed quite well. And you mentioned, declarations and the not one size fits all approach. Let's talk a bit about that and focus maybe on qualifying declarations and what that means, because I think that's an important element, and it brings in various other constituents who play a key role in this process.
I'm glad you mentioned Section 1110 because the key declaration is the Bankruptcy Declaration, Alternative A, which most countries have ratified. And I'll come to that in a second. But just to double click on your point, Dean. I mean, the last amendment, Section 1110 was 1994. So that 35 years after, we were still working on it. And having that bit of history puts things into some perspective here, frankly. But the declarations, I want to stay on this. There are a couple of key declarations, but from a big picture kind of commercial, perspective, there are a couple that really matter. And the bankruptcy one is issue number one. I would just like to give the, listener just a little bit of perspective on this, kind of in two senses. The first sense is that the natural process for a treaty would be to say, some countries do it this way, some countries do it that way. Let's find a common ground. Let's find a common ground between different countries, different legal systems. That was not the approach taken here in general or in bankruptcy. That the approach taken here was to look at what was the best practice against the criteria of the commercial objective. The treaty was purpose designed to produce an outcome, not to reflect different legal systems. And the main outcome was bankruptcy, because outside of bankruptcy, things sort of sort themselves out. If there are resources to pay damages, it might take time. It might be frustrating, but bankruptcy is the zero-sum game. Everything needs to be tested against what happens in bankruptcy. When we negotiated the treaty, we made that point. There had never been a treaty in the commercial law field that dealt with bankruptcy. There was one treaty that had one provision that said the real rights of a financier should be respected in bankruptcy, whatever that means. It's so vague, it means nothing. But it was the only thing ever stated in bankruptcy. There was a distinction between leasing and secured transactions on the one hand and bankruptcy on the other. And the notion was you could change the law on secured transactions and leasing, but not bankruptcy. That was too sovereign, too important, too policy oriented. And these were completely different worlds. Even in schools, you have different people who teach bankruptcy compared to these other commercial law. We persuaded UNIDROIT and the governments that bankruptcy needed to be addressed. It was so sensitive, it needed to be a declaration. And there's three choices. You could either go for alternative A, which is the so-called hard rule or the AWG rule, declaration B, which was the soft rule or the French rule, or you could do neither and leave your own bankruptcy law. Of the 85 countries, about 60 have gone for the hard rule. More than that, one country, Mexico, went for the French rule, and the rest kept their own law, although a lot of them are changing it more and more. So we now have 60, I don't know the number, 60, 65 countries that have Section 1110, better than Section 1110 on paper. I don't want to get into the details here. You think about the enormity of that. I was at a conference with a few colleagues, maybe people on this phone call, in Brazil, years ago, and we were talking about the details of alternative A, and we were arguing about this number of days or that number of days, and we remembered what happened before, when there was no bankruptcy rule, no Section 1110 equivalent, and what a different world it was in trans Brazil and these older bankruptcies. And you have to take a look back at it. So we have a provision that just cuts through bankruptcy. And what alternative A says basically is an airline has a specific number of days that it declares. Most declare 60 working days, the same period as Section 1110. Some have declared less. I think none have declared more. And at the end of that period, they either must cure defaults or give the aircraft back. And during the period, they need to protect the value of the aircraft in accordance with the terms of the lease. There's lots of other details. And the most notable one during COVID was there's an anti-cram down provision, which was used to great effect during the various scheme of arrangements at the beginning of COVID to protect the rights of the secured creditors and the lessors. And I should say that the English bar, which originally some parts of the English bar had a hard time understanding that their new state-of-the-art scheme of arrangement with cross-class cram down would not be used in a Cape Town transaction because of subsection 10 of Article 11, which coincidentally could be read as Section 1110. But it turned out that that one provision really gave enormous comfort during COVID in the schemes of arrangements. And the English bar came around to that point of view, after a little bit of time and effort. And so this provision has been enormously helpful. Everyone, they might not realize how much they benefited from it, and the effect that it had, the preventative effect that the provision has. You might see something that happens, and it's hard to see what doesn't happen because there was a shield. This was a shield. What would have happened if there was cram down? There probably just would have been a cascade of these cram downs all over the world during COVID. And I think Cape Town was a real shield against that happening. So that declaration is key. And then there are other declarations that really require the courts to move fast or to permit self-help to controversial things, which are very important. Most countries, the vast majority, well over 60, probably closer to 70, have elected either self-help or tight judicial timetables. There have been some cases where those timetables haven't been met. Growing pains, as you say, Dean. But the time period, I look back to, say, SpiceJet, where the timetables were not met. The court didn't act in 10 days. It acted in 34. Okay, but it didn't act in 334. So again, one needs to put it into some perspective. People have complained, you said earlier, some unwarranted objections. I mean, if the standard was, by ratifying, is the letter and the spirit going to be applied in every single case? Of course, this is, that's a fairy tale. That's not the world we live in. The question is, if we look objectively at what has happened, and again, we fight through some difficult things. I'm fighting through some difficult things now with the AWG in some countries, and and they're hard. And the next time it's going to be better. I mean, that's the way it works. And we're going through those things, but countries have adopted it. Again, for those younger people, even younger than Dean, that are on the phone, deregistration, probably the single most kind of impactful thing is this IDERA. I mean, when we started, there's the Chicago Convention that says you cannot re-register an aircraft unless it's deregistered from the prior country. Deregistration was basically a weapon that any country had to prevent the grounding of an aircraft or the redeployment of it. It was, when I was young, the big battles were on deregistration. The Cape Town Convention has this provision which makes nearly automatic deregistration. Again, it has to intersect with bankruptcy. And most countries, again, probably above 65, have gone for that provision, the so-called IDERA provision. And so, if one takes a look back at what was done and how it was done in the effect, deregistration is now kind of virtually a non-issue, except in limited and extreme cases that we continue to want to sort out. But the general rule, the framework, and one of my basic ideas here is the framework is completely different based upon the changes. And it really came down to these declarations. We were, given a huge boost by US Exim Bank, frankly speaking, when they provided to give a 1/3 discount for countries that ratified with certain declarations. Bob Moran deserves credit. Got to give credit where credit is due by the leadership he showed, back when he was at Exim Bank. But that gave a financial incentive, and it set, the rules. And then when the OECD took over and globalized, and the European ECAs and Brazil and Canada, everybody adopted the concept of these declarations, these key declarations that were conditions to benefit and therefore would need to be made. So now we really have, people are speaking qualifying declarations, almost like a cocktail conversation. That's a good thing, and that means the declarations made under the Cape Town Convention that materially reduce risk. So that was the compromise we made. We had to put a lot of effort after the fact, to get it established. But I think it's fair to say that anyone who doesn't make the qualifying declarations We're talking, for example, to Italy now. They haven't ratified yet. And I think it's understood. They're going to ratify with the qualifying declarations, and I think they will, or they won't ratify. And that's the way it is, and that's the way it probably should be.
Yeah, and that leads nicely into our next discussion, because we've talked about the process of how the treaty was created, implementation, the declaration process, and what you choose. But you mentioned, the difficulties in actually applying the treaty in specific jurisdictions, and the process of educating courts, lawyers within specific jurisdictions. And it'd be really useful to talk about the role AWG plays as a watchdog to seek and hopefully ensure compliance as best you can.
I'd encourage everybody who's interested in the subject to, spend a moment, of course, after our session, and go to this link, because this, a lot about the Cape Town Convention is absolutely unprecedented, as we've said already. What we're discussing now is unprecedented. The AWG made a decision that, all going back to this issue of being able to rely on the treaty, and for it to be implemented and complied with. We decided that the best way to do that was to provide transparency, and to provide market pressure, and to increase, the reputational costs to the government of not complying with the treaty. So we created, about 4 years ago, a thing called the Cape Town Convention Compliance Index. It's an open source document, doesn't cost any money. Just put your email in. It is both a reportive and a predictive index. It reports what a country has done, everything it's done. How have they implemented it? Every case that we're aware of, and we work with 250 law firms around the world. We are aware of almost everything. Unlike, your use of your trusted counsel, in a country, we use mini counsel. We have them agree on things because we take positions that people, often rely on. So we report and we predict what they'll do based upon what they've done in the past. We take into account the role of precedent in their system or not in making that prediction. We take into account other factors. It's a very sophisticated thing. We score countries from 0 to 100. We make statements about whether it's highly likely, unlikely that they would comply with the Cape Town Convention in a similar situation in the future based on what they've done in the past. We regularly update it twice a year, and we issue watch list notices whenever an event that might impact scoring takes place, like the commencement of a bankruptcy. Those provisions, the full information and the scoring, is available to everyone. People rely on it. The government knows they'll be scored, and it has the effect, clearly has the effect of incentivizing compliance. I'll just give you a kind of personal I'm going to get to India in a second, but lots of eyes are on Go Air in India. When we issued our watch list notice, 8 newspapers called your humble servant asking about that watch list notice, and I think about 5 of them wrote on it. That just, I think, says it all, right? And one of them, the major one, I think was Bloomberg, said, referred to, I'm not sure I would agree that AWG is a watchdog. I don't think I'm a watchdog, but they said the index or AWG were watchdogs, that had the objective, realize the objective of putting pressure on people. So, the effect is strong, and that's not an isolated case. We also went back to our good friends at the OECD and looked and reviewed what they've done and said whether we thought countries really met the criteria. So whether something's on the list at the OECD, you might want to look at the AWG's assessment. of whether they should be eligible. It's all there. It all comes down to transparency. And again, I really have to thank the large number of people that are involved. Again, 250 law firms. AWG, we take responsibility for the scoring. We have lots of checks and balances with lots of people, but it really is a very large community working through these things in a constructive way that allows us to put out something as credible and reliable as the CTC compliance index.
All right, so I'm mindful of the time, Jeffrey, and I think there are a couple of specific jurisdictions that I think we'd like to get some discussion on. Russia being one, of course. There was a lot of discussion about CTC in the context of Russia's, quasi-nationalization of hundreds of Western-built aircraft following the start of the Ukrainian conflict, and some question whether CPC was at fault, and somehow it should and could Cape Town have prevented any such thing. Why don't we talk about Cape Town in the context of political risk and put it in the context of Russia, if you would. Yeah,
this is an important subject. I'm glad you raised this. First of all, the Russian situation was definitely the most complex legal, commercial, political thing I've worked on in my 35 years as a starting point. Immediately after the invasion, I was on a session and someone said, well, the fact that you can't repossess aircraft from Russia, shows the Cape Town Convention doesn't work. So in the list of unwarranted criticism, I said something like, are you really saying that a country that's disregarding their, every imaginable treaty they have, invading the sovereign territory of another country, doing X, Y, and Z that I won't say in this public situation, that the Cape Town Convention was going to stop that? There is an outer limit, a political risk outer limit in any law. Russia, is the exception that kind of proves the rule, and I think that those people that criticize the Cape Town Convention, they have a lot of other people to criticize in basically every other treaty that's ever been written, and they might as well then criticize all international law and international institutions. There's an outer limit, but within that outer limit, the more interesting issue was what happened in third countries when the aircraft flew back to Russia. Putin wrote, and we had copies of the letters, he wrote to civil aviation authorities saying, do not detain the aircraft. That would be an unfriendly act. Let them come back. There were a lot of aircraft, about 75 were repossessed. Some were out of the country, doing maintenance. Most flew back. This happened. There were cases of people running to court in the middle, early in the morning, late at night, the aircraft not going through. We were successful, in a minority of cases in preventing the aircraft. The majority of aircraft went back. But I can tell you that if this happens again with Russia, with everybody now wise to the treaty obligation, we have an academic project which was devoted a session with the leading academics in the world devoted to the legal position of third countries if this should happen again. ICAO passed resolutions saying that Russia violated the Chicago Convention, and that corpus is out there. If aircraft fly again to other, unfriendly countries, I think you'll see a very different result. In fact, Aeroflot stopped flying to China when China kind of made it known that that they were in a difficult position, and there was a period of time, you might remember, when a bunch of aircraft were going to China and it stopped. So we'll see what happens over time. The connection between politics and law is, there's some big issues here, but clearly the violation of international law, as I said, made a big difference. I think, generally speaking, the Cape Town Convention and international law generally it doesn't eliminate extreme political risk. Of course, how could it? But what it does is it really reduces it very close to the outer part of the spectrum. Countries do not, at least they don't want to say, they might find an excuse, they might be disingenuous, but once you have the heavy artillery of a rule-based treaty, political risk is reduced to a degree. Doesn't eliminate it. There may be a smokescreen, and we see that, and we've seen that in Russia, and we see it elsewhere around the world. AWG is focusing on that issue. We are trying to be as transparent and clear as possible, as we move forward. I think that, again, in sum, what the Russia case will show us is, on the one hand, the outer limit, what any treaty could do, but the power of a treaty of this type. We've seen the Cape Town Convention already referred to in some litigation involving Russian aircraft. We'll see where this goes. And I think, maybe we need a little more time. Next time we discuss this, Dean, I think we might want to revisit this issue.
Great. Well, let's, because I know a number of our viewers are interested in some of the other situations that you've spent a lot of time with. You mentioned Go First in India. Obviously, you've got the Vietnam situation, and you can maybe chat a bit about China as well. But let's talk about these kind of noteworthy global cases that you've been dealing with of late.
Yeah, I'll take these up quickly. They're not quick cases, and they're ongoing, so I have to be a little careful. But I'll take each one up, and I'll talk about maybe the bigger theme and then the specifics here. I think kind of India stands, and the Go Air bankruptcy, I'm not going to go into the details. I think India in general and Go Air kind of stands for the following propositions. Number one, Cape Town clearly has shown a lot of comparative improvement. If you went back from Kingfisher to SpiceJet and you look at the continuum there, you see that. Number two, we have a problem on the implementation of the treaty in India. They implemented the civil aviation regulations, but they never implemented the treaty to have priority over bankruptcy. We've been saying this for a long time for anyone who's been listening. And now it is come home to roost, right? There's a conflict between the Indian bankruptcy law and the Cape Town Convention because India didn't pass primacy legislation. No one should be surprised if they've been doing their homework. Now, it is a problem. We are working it through. We are guardedly optimistic that legislation will pass in this current term. Nothing like a crisis to get get people's attention. We're working with the government to get a Cape Town primacy rule that would really be the stepping stone to a much more robust system in India for all of their deliveries, which are coming up. Without that legislation, you know what you're getting into. So we are, doing our best within the tools that we have. There's a lot of good lawyers out there working very hard. I think, the case, even the worst case, is going to be, a lot better than the bad old days. But until we get this done right now, the bottom line is there's a new bankruptcy law. Go Air or Go First is the first voluntary bankruptcy case in which the new bankruptcy system is kind of trying to disregard creditors' rights and lessor rights. And we are working with lots of people, day to day to minimize that. In the Go Air case, we are working for the AWG members. We do intervene on their behalf, on behalf of our members. We're spending a lot of time on this. And in parallel, we're pushing for this legislation to fix the problem and then to build upon that going forward. The Vietnam case stands for the proposition for me that the hardest place to work are courts, and especially court systems with very different backgrounds from kind of Western thinking, like the Vietnamese court system. In the Vietjet case, which is, again, ongoing, and I don't want to comment, there have been a lot of kind of good things that have happened, but a few bad things that have happened. One thing I should say, the AWG's compliance index, when someone doesn't follow the treaty, we issue a notice because we want to perfect. We don't usually kind of applaud people for doing what they were supposed to do. So sometimes our notices, are perceived as more negative because we're trying to fix things. There were some good things in Vietnam. The Civil Aviation Authority really performed very well. They had an idea. They went way beyond anything anybody ever would have imagined from the Civil Aviation Authority in Vietnam. They deserve a lot of credit. We spent a lot of time with them. But the court system, which was not informed, came in and made a non-compliant court decision. And, they weren't educated on this. The lawyers may not have raised it in like ex parte proceedings. And so we have a problem there. And we're trying to now educate them and get that fixed and get that changed. And we will get it fixed and we will get it changed. But, it happened. And it happened at the court system. The big institutional part of the CAAV acted in a compliant way, but we did have this court decision that we need to work through, and we're working through it. So, would we have liked a better result? Yes. Do I think we're going to work through it? Yes. And we're going to, keep at it. Finally, China. Another example, China probably stands for the proposition that there's, and this will surprise no one, a much more complex interrelationship between kind of law, politics, and practice, than a lot of other places. The institutions in the Chinese system have, interconnections. The ebb and flow of politics affects the ebb and flow of everything. So Cape Town shouldn't be different than all that. We spent a lot of time, especially before COVID, working very closely. They implemented their law well, and a lot of good things have happened. Just to show you a cultural point, the Civil Aviation Authority, the CAAC, required airlines to take a deregistration, a Cape Town test to know what they were getting into before they entered into transactions, which showed that they really were being very diligent about it, to make sure everybody was informed. We have had a few problems in practice, especially in the relationship between the court system and the Civil Aviation Authority. Again, these are things that need to be worked through. We're setting up our first set of post-COVID meetings right now to work through those. So is the situation, in China perfect? No, it's not. Are we in a lot better position than we were? Yes, we are. Do we have more work to do? And are we optimistic? Yes, we are. So I think that, it is something that these are big, important markets, and AWG is going to continue to work and to solve problems in these big, important markets.
There was a couple of questions from the audience, one regarding Philippines. I don't know whether you've got any updates or thoughts about the Philippines, and then how Colombia reacted principally during the Avianca bankruptcy, and whether there's any takeaways from either of those.
Well, the first takeaway is the Philippines have not ratified the Cape Town Convention, and so the risk there is, is higher. You don't have the treaty behind it. You have all the reasons to ratify. We've consulted with the Philippines. We've not spent a lot of time with them, frankly, recently. They're certainly on our list of countries that we would like to have. There are on the list of countries where we think there'd be a large qualitative improvement in ratifying the Cape Town Convention. Thailand, Philippines, are in that category of countries, large qualitative improvement. And I should say, we have a very strong sort of base in Southeast Asia. We have a contact group anchored in Singapore, Malaysia, Vietnam, Indonesia, where we've really elevated the thinking of lawyers and institutions there. And I think, they would join, both of those countries would join our supportive network. And I think the future would be a lot different in those countries if and when, and if our questionnaire has any leverage with the Philippines and would like to work with AWG on their ratification, you know where to find us. Colombia was very interesting in a couple of ways. And if you do go to the AWG compliance index, you'll see analysis of of what happened in those cases. And they're ongoing, there are ongoing Colombian cases. Again, I want to be a little bit careful. First of all, Colombia was a country that was considering just overriding its law during the COVID period, and one of those countries that we needed to work with. Colombia is also, we don't have time, Dean, maybe another day. AWG is doing a lot of work on cross-border bankruptcy. Colombia is, again, one of the countries in which we would have to discuss that a bit more. But we did see a number of successes in Colombia. We did see a couple of problems in Colombia that we're continuing to work through. We're including one right now that we're working on. I would say that, and again, I really don't wish to speak on things because these issues are connected to some ongoing things. I don't want to go too deep here, but I would say we've been pleased with the Colombian government approach. We do think that Colombia falls into the category of a place where, good, solid information and consultation as to what's required will produce benefits. And if they're left alone, outcomes will not be as good. So Colombia has sort of been, kind of a mixed jurisdiction that we're continuing to focus on.
That's great. And I'm conscious of the time, so I'm going to skip right off to our last slide, Jeffrey. And this is really getting to, the looking forward part of the discussion. What are your objectives of AWG on a go-forward basis? And, how should we be, defining success here?
Given your skillful moderation, I think this is an opportunity to, in a way, tie together things we've already said. I think we've foreshadowed the things that we think are important. I think first and foremost, there are definitely countries that are outside of the Cape Town net. Philippines, Thailand were just mentioned. The changes to those countries, and there are others, would be a lot different. Even a country, like Italy, where there were historical problems and offshore registration, because of perceived issues in Italy. I think it is clearly AWG's objective to bring more countries into the system in the proper way. That is an objective. Number two, all of the systems that we've worked on compliance are getting more and more mature, more and more robust all the time. The cumulative effect, there are cases around the world, there are examples, we have network effects here. And so we are continuing to learn. People who might look at the AWG website or legal advisory group, we have 10 working substantive groups. We have 26 geographical groups working on every imaginable issue, cross-border bankruptcy, courts, CAAs, everything. And we're continuing to work tirelessly on that because, we have a great advantage in the Cape Town system because we were involved in working on it. The truth is good for us. That is, if it's properly applied, it is in our interest of the financial community, because it was drafted by us. The place where there's a problem is where it gets distorted through kind of government channels, through the implementation, or judicial or administrative process. All we need is countries to do what they've said. That's all we need, no more than no, and that's all we ever say when we go to. All we're asking is that you follow the treaty obligations that you've undertaken as a matter of international law. So we're continuing to focus on that. Courts are definitely the main place. Civil aviation authorities, as I've said, I think several times, they're not perfect, but I mean, we're 90% there. It requires every time there's a new person, we need to keep working. The place is the courts, because courts are not expert. There's a lot of things in the Cape Town Convention that take away discretion of courts. Courts don't like to lose discretion. They're courts, they're judges. They like to do what they think is right and what they think is fair. I'm not passing a judgment except to say their country has stripped them legally of that discretion. They've made a a decision. A court is an organ of the country. So, that's an issue that, water under the bridge. Now they are to, to work within the system. But that's still, is easier said than done. Judges are, they tippy around judges with good reason. Nobody wants, you're under contempt, AWG. So, we're careful about that. And because of that, AWG, we are intervening more and more as experts. We're often asked to intervene for our members. We're often asked, we're having a constant conversation of the role we're playing in India. It's almost a daily conversation. Whether we take action or we might take action, the very possibility we take action has an effect. And so that is, I think, going to increase more and more. We act for our members. We are a member, driven organization, and we act, for our members when they need our help. And I can't, say enough about, the role of the law firms around the world, who work with us, day in and day out. We would be, without having that information, that expertise, and combining it with the understanding of Cape Town, if one synthesized, the last kind of 15 years back to commercial objective, diplomatic process, law as subject matter, the law point is really the intersection between the treaty and national legal action. That's really now where things are. And so we need these people all over the world, and we have, a great structure. And so I would just kind of close by saying, Dean, that it's a pleasure for us to speak here at ISTAT and to spread the word here, because we really, besides loving ISTAT and its members, we do want everyone to understand this and to become and get involved, because it is this, this knowledgeable approach to this subject matter that will keep expectations, have appropriate expectations and help us continue to perfect the system.
Well, Jeffrey, thank you. That's a great way to wrap up the discussion. I'm particularly pleased that this is recorded. And so, this is worthy of a playback on occasion. And certainly over time, people will come on and look to this. And it's a great way to memorialize kind of the history and where we've been, where we are at this point, and hopefully where we'll be going. So, Jeffrey, thank you. I want to thank everyone that has participated. And with that, we will wrap up today's session. Thanks again, Jeffrey, very much.
Thank you, Dean. Thank the colleagues at ISTAT.